Yes, Mr. Rowe.
May it please your lordships, I appear on behalf of the appellant, Mr. Ellis, along with my learned friend, Miss Riley, who sits behind me. My learned friend, Miss Taylin, appears on behalf of the respondent, as she did below for the defendant. The court will know that this appeal arises from the exercise of the right to education in a student studying a master's programme, so tertiary education, by distance learning means. He, in this particular instance, is a student who is a serving prisoner at the same time. Education being part of the rehabilitation integral purpose and objective of his imprisonment, and the studying of it serving, of course, a wider public interest in that sense, as well as his private personal interest in completing successfully a course. Restrictions may be placed, we accept on behalf of the appellant, on a prisoner studying, but where lawful to do so. But we submit as a starting point, like other rights that are not expressly taken away by imprisonment, i.e. the right to liberty, which is restriction in that way, those other rights remain for the prisoner in educational terms, in the same way as one sees for private and family life or Article 6 rights and those types of matters, where the latter in terms of access, for example, to a lawyer outside and that sort of thing. So with visits, with who may telephone, with correspondence, prisoners have rights. They can be restricted where justification is shown for that restriction of the right. We submit essentially the same applies to the right of education being exercised. The challenge was brought, by way of opening observations, by judicial review, because of course the lawfulness of restrictions that were ongoing at that time, in particular various matters, but one of those being access to information technology facilities, to online websites. Another particularly important area of the judicial review was the Chromebook having been removed and the decision not to return it. So judicial review was the mechanism by which both public law rights were, or public law duties were asserted, and by which the Article 2, Protocol 1 right was also asserted. The denial throughout the studies of access to the online university e-learning campus, library information, the virtual campus of the university, was a feature of the complaints and is of importance when one looks at comparable authorities from the European jurisprudence. There was, in that respect, as we'll see, requests made for access, but there was no evaluation, assessment, or reasoning provided to justify that restriction being maintained throughout the entirety of his education. In terms of the domestic law challenge, as the court will know, he was successful in part in that on ground 4 below, an unlawful decision had been taken to remove the Chromebook, taken by the respondent, which removed the Chromebook and at the same time imposed restrictions on the virtual campus access within the prison system, a different type of virtual campus, the prison's own version in the IT facility, which went hand in hand. That decision to remove access to the Chromebook and IT facilities was subject to challenge. There were various other complaints which the court will see from the papers and which I will attempt to deal with in very shorthand so far as they're relevant, appreciating the role of the court and its function in comparison to findings of fact for the learned judge. But there is in this case, of course, the question if the appellant makes good on his primary submissions that there is a requirement to consider proportionality of restrictions, then the learned judge's findings of fact, such as they are, will inform that, but the proportionality exercise itself is not equivalent to a finding of fact, and is a matter that the court considers in the round as to whether or not the judge either didn't perform that exercise, in which case the court does, or did, in which case the question for the court would be whether the judge was wrong, and the court would come to a different conclusion and regard the judge as wrong. So I will deal with those in more detail, of course, as we go through the submissions. The focus of the appeal is upon the legal implications of the unlawful restrictions or unreasonable, unjustified restrictions in terms of an Article 2, Protocol 1 application. Below, the learned judge quashed the decision to refuse the Chromebook and IT facility decision of the 6th of April 2022, but dismissed the breach of Article 2 claim, both on what she describes as the generalised complaint, which is set out in one part of the judgment as her second Roman numeral part of the judgment, and the third element, the Chromebook removal, she also regarded, whilst unlawful in domestic law, as not amounting to an Article 2 Protocol 1 breach.
Well, just focusing on the decision of the 6th of April 2022, if the judge has held that it was unlawful in domestic law, why should we go on to consider whether the same act was unlawful under A2P1 as well?
Well, my Lord, if one has in mind that in some articles it is established that if something is not in accordance with the law, that is in itself a breach of the right, which applies in certain ECHR articles, it's not clear at all that that same approach is open to the appellant in these proceedings on Article 2 Protocol 1. We'll see that when we turn to the authorities. It may be a slight oddity. It struck me perhaps as being such when I looked at this point. But it does appear from the authorities not open to the appellant to say that the fact that a decision or an action is unlawful in domestic law in itself means a violation of Article 2 Protocol 1 in the sense of the right. That is unusual, I would respectfully submit, when one looks at articles of the Convention and their application. Ordinarily, the requirement of acting in accordance with domestic law is a paramount starting point, as it were, before one moves on to more nuanced areas of the right. But that is something which I'd ask the court to just have in mind. But my submission at the moment is it's not clear or not clearly established that that would be open to me to argue when one looks at the dicta that's considered Article 2 Protocol 1. Both in Strasbourg and domestically. But I'll try to point my lords to where that comes up as I go to the relevant cases on the principles.
I was making a more elementary point, really, which is I quite understand why you seek to appeal against, anyway, some aspects of the judge's rejection of your client's claims. But just focusing on the decision of the 6th of April 2022, he won on that below, albeit only in domestic law. So why does it matter?
Well, ultimately he was dismissed on his Article 2 Protocol 1 claim, which we submit is well founded on the basis of that particular interference, as well as the online website restriction, which was never justified. So we do respectfully submit that there is relevance to that finding of unlawfulness in the sense that it indicates that there isn't a justification. It doesn't per se lead to a breach perhaps, but it does indicate the lack of justification for that restriction, which if one is required to engage in a global or cumulative exercise, adds to the picture that the appellant would respectfully rely upon. So it may well be that, bearing in mind that judgment, which isn't challenged as it were in terms of the domestic law, that the simple point to make about the Chromebook is that there was a period of time that the judge found that he was deprived of a Chromebook, and ultimately, whilst she didn't criticise certain searches that had taken place after that time, which removed documents, etc., and then returned them, the action of taking away the Chromebook on the basis that he'd done something which wasn't part of the course, i.e. the WAQF search advertisement draft in relation to a form of funding the agricultural sector in parts of Africa, that the judge found had already featured in his request for books and other things through the course learning assistant. That person was away when the issue came up, and erroneously it was decided that these things were outside the scope of his work, that he was permitted by the compact for the possession of the Chromebook. So that essentially can be taken as read as a feature of the evidence in terms of what we say amounts overall to an Article 1 protocol, Article 2 Protocol 1 breach, if it requires one to look at it cumulatively. My primary submission is that where you have a positive restriction, such as the removal or such as the website non-access to the particular websites, that in itself requires justification. And it's the absence of justification and the absence below of an inquiry into justification on a specific basis, not a generalised basis, of course. Generally, one accepts one can have, in principle, restrictions on a prisoner's access to websites, even for the learning purposes, where that is the assessment that it cannot be safely achieved. So the balancing exercise is undertaken, and one arrives at a final decision which is not within the area of correct discretion for the decision maker. But that's not this case, because ultimately, despite the request, there was no consideration of it, and there was no justification provided as to why it shouldn't be, having looked at it properly. And as well as invoking the right, we also invoke non-compliance, as it were, with the domestic policy on deciding these matters, which doesn't say that we're not allowed to do anything that might mean someone had to spend time on an individual assessment. It says the opposite. It says you must assess individually, case by case, whether to allow access to IT facilities. So we respectfully submit that the learned judge falls into error, and this is the first issue, of course, and the principal ground, in applying an incorrect test to whether or not there is a breach of Article 2, Protocol 1. And we respectfully submit that, bearing in mind the relevant Strasbourg jurisprudence, the learned judge ought to have conducted the familiar exercise of considering justification, and that involving the four-limbed proportionality test that the court will be familiar with, in the way that one does in other instances where a right being exercised is interfered with. The second element to the appeal is second ground, concerns the question of looking at events that post-dated the issue, and that's why I mentioned earlier that judicial review was the process invoked here because of the ongoing nature of concerns and the need for orders that are appropriately sought in judicial review. But the learned judge, when dealing with the case somewhat down the line in terms of temporal proceeding, did have a concern about looking at events that post-dated the claim being issued and the permission being granted. Now, there's some debate, as you may have seen from the papers, between the parties as to what the judge precisely was saying or deciding about the previous events and what relevance or not they had to her assessment. The appellant puts the matter in this way. Firstly, that we submit that the correct reading of what she says is that she did put to one side matters that occurred even at HMP Hull, the first prison. No complaint made that she says it's too late to invoke Isle of Wight prison because it's not fair for the defendant to answer that. It's too late in the day. But in relation to Hull, we submit respectfully that she does put aside certain matters because she hasn't regarded them as complaints that are before the court in of their own right. And specifically, this relates to the period in which there were requests being made for access to the online university website. During that time, the case was ongoing, but the learned judge doesn't make reference to those in terms of her reasoning or judgment or assessment, evaluation of the case. She notes the complaint about them in general terms is evident before her, and we can note that in her judgment. But the central approach taken, we submit, is to put those to one side and not to identify them as relevant matters that had to be part of the evaluation, justification question asked about them. Now, either the appellant's right that she did exclude consideration of them on their own basis in that way, as part of the Article 2 Protocol 1 claim, or she failed to deal with them by way of reasoning and judgment on them, bearing in mind that they'd been raised in the case before her, and bearing in mind the importance in the application of some of the European case law, which we submit has similarity and therefore instructive guidance on the point. So that's ground two.
Can I just make sure I understand what the question is? We've been discussing already the decision of the 6th of April 2022. The judicial review claim was issued on the 5th of May 2022. your client was transferred from Hull to the Isle of Wight on the 18th of November, 6 months later. The normal rule is, isn't it, that except by consent, judicial review challenges to acts and omissions done before the claim's issued. And what, if there's a fresh decision, then sometimes it can be included in an existing claim by amendment. Sometimes a fresh claim has to be issued. What are you saying? In what respect did the judge go wrong in law in saying that you couldn't rely on subsequent events?
We respectfully submit the distinction is that this was not solely a decision being challenged. Under the Article 2 Protocol 1 claim, so the ground that related to the Chromebooks, specific decision, specific target as it were in that way, the complaint about Article 2 Protocol 1 was an ongoing failure to afford the appellant the right to education by its impeding in very many different respects, I appreciate, that were set out within the pleaded claim. So the ongoing nature of it, without taking your lordship unless it assists to the grounds at the moment, but paragraph 12 thereof listed a number of things that were of central complaint to the exercise of the right to education that were being impeded, including the websites and other things, tutorials and telephone access and various things. Within that, the complaint was, you're not affording me, it's an ongoing unlawful omission or act on your part. It's not a target decision, as it were, that you've decided X and that's a breach of my rights, but rather you are breaching my rights. Now, obviously, if you don't bring a judicial review, it's after the event. That would be in the usual way, a concluded situation in which you bring a civil claim with no requirement to obtain the relief that judicial review seeks. But in this case, the issue between the parties and in relation to ground 2 with the learned judge's approach is that where one is obliged to bring a judicial review in order to seek relief from an ongoing situation, but concurrently have a right that is being infringed on an ongoing basis by the same public authority, so that the claim is conveniently joined, as it were, rather than two separate claims, particularly given the overlap as to questions of justification that we submit would arise in both instances, whether you had a civil action or judicial review. We submit respectfully that procedurally it's no impediment to the court, subject to fairness to the defendant in terms of evidence production and notice of points, which is why, as I say, we don't challenge the learned judge's exercise in relation to that point, in relation to whether or not there was a fair opportunity to deal with the Isle of Wight, because of the timing point. But we do respectfully submit where documents and other evidence was in the bundle and was part of the pleaded claim against the Article 2 Protocol 1 breach. Temporally, there's nothing objectionable about having full regard to the continuing act and its consequences, rather than being limited to a point in time at which the claim was issued or permission granted, which would be an arbitrary basis on which to evaluate a continuing act.
Okay, well, you need not tackle this now if you want to. I just flag up my concern about this, but that's a topic
yes. to
revert to.
I'm grateful, my Lord. There are some authorities which may help, which
yes.
I'll try to go to when we deal with ground. The last ground is one that posits that the learned judge was wrong on the facts and on the approach, whichever it may be, to Article 2 Protocol 1 that the court has decided on ground 1, in not upholding the claim in this particular case.
Does that just follow from the other two grounds?
If the other two grounds are made out, then we would submit it may. But it really, I think, is probably of more utility to the appellant if he were unsuccessful in establishing that there was an error of principle in the way in which the judge had gone about ground 1, the exercise, and there has to be a more holistic or cumulative exercise the court considered the judge had done, we would respectfully submit that the court is entitled to say on the facts that she was wrong to reach that conclusion.
And what is the order that you invite us to make if you're successful?
My Lord, firstly to allow the appeal, and secondly to declare the violation of the appellant's Article 2 Protocol 1 rights. The question, as the court will have posited from the material, is the court should always consider what just satisfaction follows.
Yes.
The majority of case law would indicate in circumstances such as this that it is rare that there is any damages award added for just satisfaction.
The declaration of the violation is sufficient.
That has been said in more cases than not.
Yes.
I will point out to the court which said which, as it were, once you have some, once we've gone to some of the authorities. But each case will be a fact-specific exercise on that front, of course. And there's very little, as usual, there's very little guidance on what principles are being applied to Strasbourg's decision-making on that particular point. There are some examples where damages were, in a modest sum, were awarded, and that may be more consistent in a way with the Ombudsman's practice in the UK. But the question for the court is Section 8 Human Rights Act to try and emulate what Strasbourg would do in terms of just satisfaction, and that's the approach that I'll invite the court to consider.
Thank you.
My Lords, if I may then turn to the facts briefly, just to posit the claim, as it were, that follows and the appeal grounds that are argued thereafter. Three elements, really, to the facts that are relevant. The claimant's circumstances, firstly. Secondly, the restrictions placed upon his studying. And thirdly, the findings of the High Court in terms of domestic unlawfulness, which perhaps doesn't need to have much said about it. The background, of course, is a prisoner, the appellant, who has sought to educate himself whilst in prison, having entered the system aged 19, ultimately seeking to undertake his doctorate, but in the relevant period of undertaking his master's by a distance learning course that he'd been approved for by the prison governor. The importance of educational attainment and rehabilitation to a prisoner who seeks, after many years of incarceration, to rejoin society in a pro-social way is self-evident, of course. At material times, just in terms of chronology, the court will have seen that there's one provided by the learned judge, but in general terms, he began this particular course, which is a research-based Masters of Science in Sustainable Development, arranged through the School of African and Oriental Studies in the University of London. He commenced that in October 2018. There was then some hiatus for health reasons with a cancer diagnosis in 2019, and he resumed the course in 2020, and we're primarily concerned with events in the latter stage of 2021 and 2022, in which he was engaged actively in the study of the course, and there were some dates in relation to when matters were required that one can summarise in this way. There was a resumption of the course noted to be in January or February 2021. There was taking away of the Chromebook in January 2022, 28th of January 2022. He had at that point a coursework deadline in February, which he was unable to meet. That's paragraph 25 in the supplementary bundle at page 11. He was unable to edit for a water and land management module his coursework that was required. His view, as the court will have seen, is that it cost him his marks, which he sets out in the statement in the supplementary bundle tab 3 at page 21. Page 21 to 23, paragraphs 16 and 19. He explains why the feedback from the course tutor was to the effect that it needed more editing. It hasn't been done because it was a one-shot presentation.
We can't resolve that.
No. The way in which it appears in the judgment is that he's completed his course, so that should be enough, as it were. What, with respect, my submission is about that is one cannot look at result in that way. the appropriate result of provision of the right is that you're able to exercise that right effectively. One can never know what the course mark would have been in the counterfactual if unlawful, unnecessary restrictions weren't imposed. So it can only be a subjective view. The subjective view may go to questions of just satisfaction, but it is no more than a subjective view that it cannot be subject to proof what the grade would or would not have been. But nor, of course, in our respectful submission, does the exercise of the right depend on whether someone fails a course or not, for example, which may be an implication of the way in which it's put in the learned judge's assessment. Having completed the course, you may have nothing to complain of. Well, with respect, we respectfully submit that is not the be-all and end-all of exercising your right to education, and one cannot know what grade you would achieve, fail or succeed if the right is unlawfully interfered with. In terms of the impact of the removal of the Chromebook and the IT access, the timings one can see in the evidence are from the email from the course director, which is at page 162 of the supplemental bundle. He was due to submit work on February 2022, which was the final week of the course. So in terms of anxiety and distress that is caused by a breach of any right, he was in the midst of trying to provide finalised material and unable to do it. There were some extensions then to the dissertation that were required, which had also been due in April 2022, had to be extended eventually to restart in August to an October date. Those are set out in the email on page 166 from the course tutor, who deals with the point at questions, answering questions 3 and 4 on that page. Unless the court wished to see it.
Sorry, which page? It's
page 166 of the supplemental bundle. I might just invite the court's attention briefly to it so you have the page. Tab 8 of the supplemental bundle.
We have no tabs, but we do have pages.
Right,
166.
Page 166 of the supplemental bundle. The answer to question 3 indicates the dissertation is due on Friday the 22nd of April. The course tutor explains the problems impacting on his study from not being able to work on this dissertation. And then in terms of timing, so I've answered to question 4 as well, in relation to the dissertation and extensions.
But in the end, he completed the degree, and is it right? I got this from the respondent skeleton. He was released in January this year.
I've no instructions that disagree with that proposition. Oh yes. So, accepting that the extensions do come, and he is able eventually to complete it, his own view of it being that the feedback he received was that there'd been a lower mark, 62% on the module that he couldn't edit, the water and land management module. This is set out in his statement on page 21 of this bundle, paragraph 16 and paragraph 19. This paragraph 16, he refers to the grade there for the document he couldn't edit.
Yes.
And paragraph 19 over the page, the overall mark effect of that. as I say, I accept that is simply a view of the appellant which cannot be, as it were, independently assessed in the counterfactual way, but it does go to the effects or what he was experiencing in terms of accessing his education, in that he effectively wasn't able to access the education at all during this period of time, whilst it was a crucial period of time for the information to be for the work to be completed, for the study to be completed. So the effect of that will obviously be more than if there had not been any deadlines and no impact on what he was studying, and that it was all resolved very quickly without impact on these deadlines and the study that he was undertaking, or in terms of its thoroughness in his ability to actually effectively access that provision. So the court, as has been said, knows the claim then began in the beginning of May, or early May, on the 6th of May, sealed N461, and then at that point he was receiving 2 mornings per week of computer access, and that wasn't regular, so there were about 10 sessions in a course of 18 months. This is paragraph 18 on page 9, is the first statement. And then he explains paragraph 24, he would be restarting the dissertation now in August 2022. And he submitted the dissertation in October 2022, paragraph 15 on page 21. He notes the limited editing of and feedback opportunity that was provided in October. And one other thing to note is paragraph 14 is September 2022. Prison permitted him to use the virtual campus again, Mega Nexus virtual campus, to help him to save material that was then able to help him prepare that dissertation. Now, it's with respect, it's important to note the dates and the chronology of these events, because what one sees in the defendant's evidence of Miss Anderson, which was the 20th of October, is currently, by the 20th of October, by 2 or so months after, more than 2 months after there'd been permission granted, a long time after the claim had begun, a long time after the complaints had all been raised, she speaks of what was recently allowed, or what was currently the position, but that is dated specifically to recently, meaning after the September 2022 access to the virtual campus, and recently allowing IT sessions to increase. Until then, there having been just the mornings, and not until after the 14th of September 2022 could he submit in electronic form so that he could have any check and feedback from the tutor. Miss Anderson dates that paragraph 52 of her statement on page 48. It was after the 14th of September 22 meeting with the tutor that a system was found to enable the electronic submission finally of material. So that's within the final month of the entire Masters. Now, in terms of specifically, that's the chronology, as it were, of interference that occurred with IT access and the Chromebook access, and not being able to save material or submit it electronically. The wider complaints included those which are set out, as I say, in the grounds. The skeleton also refers to them. And it's probably sufficient to invite the court's attention to the skeleton, please, the appellant skeleton, paragraph 3. Paragraph 9 on page 23 refers to matters to do with access to tuition and his course coordinator, access to word processing and electronic storage, access to the internet and online resources for study, and access to learning materials in the library, books that he didn't have access to. At paragraph 13, one can see a list of matters that are extracted from those that were complained of in the pleaded case. Materially, they include no access permitted to the specialist online resources such as the university's online library or campus. That access wasn't even there at that point for the university's distance learning coordinator. Didn't have access to the site within the university, within the prison system for printing things off for him. There were a sequence of applications from May 22 onwards, which I'll come back to. So even once one moves on the, firstly considering as a global heading perhaps the online material or the IT material, that provision was either not at all throughout the entirety of the course or was only towards the end in September, October 2022. The in-person aspects, the complaints included being unable to attend the university's library to conduct research or borrow books, and the limited, conversely, limited stock that one would have in the prison library that wasn't stocked for this particular type of research. Masters of this kind of research-led focus. That's all explained further in the witness statement, but I think can be taken as read. That gives a context.
You're picking at extracts from the evidence, Mr. Rule. We are hearing an appeal from the judge. Can you point to where she deals with this part of the history and where you say she went wrong, if she did?
Yes, can I go to the core bundle then, to the judgment beginning on page 47?
Yes.
If one goes through reference to the complaints, on paragraph 5, page 49, the regulations challenge is obviously not before the court, can be ignored. Second page 50, what the judge titled the generalised restriction of access challenge. That I think, by which that should mean other matters than the Chromebook being part of the challenge. There were specific restrictions rather than simply general restrictions that were within this. But she notes there restricted access to specialist books, the university's online library, restricted access to photocopying other matters, and the claim was that alleged unlawful lack of access to a library or online resources. And then in the middle of the paragraph, one has the submission limitations to these rights are not in pursuit of a legitimate aim or proportionate to it, but arbitrary and unreasonable, reliance placed on the European cases noted there, and a similarity asserted with the claimant in the Mehmet Arslan case, the applicant in that case, with the finding of fair balance has not been received. So that includes, in shorthand, it encompasses the variety of complaints, excluding the Chromebook. The learned judge then moved on to the disputes at paragraph 10. She sets out the chronologies noted. She notes at 10, in the fourth line on page 55, the claimant's contention that restriction to online resources is another instance of the unlawfulness that he'd experienced. Over the page, he required reasonable access to the internet and asserted that a prisoner had equal entitlement to access the same quality and level of education as a person outside the system. And the claimant submitted there was an ongoing breach and a continuing act in this respect, paragraph 11. Now, when the learned judge turns to deal with before we go to her conclusion, she sets out the defendant's position. The defendant's evidence is summarised on page 61. She's set out various extracts from Miss Anderson's statement, and then gives the summary which is taken from the defendant's skeleton at paragraph 31 on page 61. Within that, the court will note the complaints at Roman numeral 3, IT facilities. One has the answer that he is now, and you can see it over the page on page 60 at the top, second line, recently added to the afternoon sessions, that the contention of the defendant as of October the 20th, 2022, was he'd been added to the afternoon, therefore, without temporally showing this, it's 27 hours per week said to be used at Roman numeral 3, and the access to the VC2, which, as I've just shown the court, was September 2022, again mentioned but without the temporal aspect. Then site access, Roman numeral 4, the Education Department provided access to sites that were cleared as safe white sites. Prior to leaving Hull, the prison was looking into how the claimant would be given independent access to the university website, not on that list. Now, the evidence about that, just to, if I could just take the court to where that source evidence is, it's Miss Anderson's statement in the supplemental bundle on page 46, paragraph 45. This is to do with the internet access to the websites, and the court will note that she confirms, for example, line 3, he is not able to access the website for the university providing his course or any online libraries. Although access to the university website is currently being looked into, there are no updates to provide at present. That remained the case at the February hearing. There is no update to that position. Now, that the appellant respectfully submits is one example of the breach of Article 2, Protocol 1 by an unjustified restriction being imposed throughout the course of his studies, because the requests having been made for access to sites which are lawfully available for those undertaking education, which are part and parcel of the education he's undertaking. If one engages in education as a student, not as a prisoner, as a student, one would have automatically access to the university website and the university online learning resources and the library resources, because that's part of your education. So if we're accessing effectively our right to education in the course, this is an aspect from which the prisoner is being excluded. Now, it could be justifiably excluded if you have the justification on an assessment made that this is impossible, or undue burden on resources, or we can't manage this for practical reasons, X, Y, and Z. But the problem we respectfully submit with the respondent's position on this is that it simply did nothing but say we're looking at it over the course of many, many months, at a time at which it knew that he was undertaking this work and had serious difficulties that were inherent in the position, because there wasn't the access to a physical library. He couldn't go out to a library, couldn't go to the university library. There were limits on the books he could keep in his cell, limits on what he could get through library facilities that were not a specialist. So all of those matters, whilst there are, as the respondent would rightly say, certain things happening and workarounds, etc., that the learned judge mentions. Those aren't to say that there is no problem with restricting access to what would be possible to obtain, and without lawful basis to restrict that access is removing part of the education from him. It's removing part of the facility that is available. So we're not asking to create a facility, create a website for me that helps, but to access what is already there, which as a student I would be accessing, and equal treatment is a part of the right to education, as the courts have held. So there has to be a justification, which simply isn't there.
Well, but with how much particularity, and who is to decide?
Well, my lord, if the first question is it available? So if the website is available, that's a starting point. It's provided for educational purposes. It's lawfully available in general to a student. You then
The university website?
Yes.
Yes.
Or within that, the virtual campus, I think it's sometimes described as in the evidence. But that is the sort of focus, as it were. That is what was requested, to allow me access as part of, you've allowed me to go on the course, I'm studying this course at SOAS. There is a website that's available for the students on this course. It's therefore in principle available to me. The only question therefore ought to be, we submit, as a prisoner, is there a justification for restricting your access to it on an individualised balancing assessment exercise? And as I say, I have no difficulty that there could be a justification presented that looked at it and said, for these reasons, that is not possible. And it's not possible on a justifiable basis, which is proportionate, balancing the interest in your education being unimpeded and able to proceed in the exercise of that to access your educational facility in full, not in restricted part.
But your starting point is that the onus is on the prison to show that each restriction is proportionate, no more than reasonably necessary, day by day.
My lord, in terms of how it applies in practice, in this case, I'm not suggesting that they should have just known for themselves. What I'm talking about is specific requests that have been made and the knowledge that this is for a course he's studying and related to that educational purpose. So it's not an unrelated issue. It is part, as I say, the way in which we invite the court to look at it is it's part of the education that he's being permitted to undertake. Yeah. And if you remove that part of it, you are removing his access to that educational facility that is there. It's not, as I say, the resources questions, etc., where you don't happen to have a type of school and the difficulties in producing a special educational needs school, for example, from a standing start. It doesn't exist, in having financial resourcing questions that cause real issues. This is a facility that's there. The only reason he's not accessing it is a deliberate intentional restriction, which could be chosen to be removed. And if you have a choice whether to impose that restriction, the only proper principled way on which to assess the exercise of that choice is on a proportionality exercise as to whether it properly balances competing interests.
Right. What are the judge's findings about this which you criticise?
We then move forward to, I don't know if it's of any assistance to the court to demonstrate the argument that the claimant below made as to the approach the judge should take, but just the note, you might note it's at paragraph 47, that an equal footing submission was made for access, and at the end, if there are two restrictions, they must be subject to some justification by Secretary of State. So I'm repeating before this court a principled submission that I made below.
Yes.
What the learned judge does, after dealing with the practical issue about what she would or wouldn't have regard to, she turns to this point at Roman numeral 2 on page 68. And paragraphs 63 to 65 are her judgment, her ladyship's judgment on the Article 2 Protocol 1 under the heading of generalised restriction of access challenge. She notes the absence of facilities or imposition of restrictions being asserted. She accepted there were operational impediments. Notes some there, but found they were not systemic under-provision or denial of access to education in the sense understood by the authorities. She mentions at the end of paragraph 63, to the extent there were security checks on materials arriving at prison or set processes for receipt of study material, indirect nature of some communication with teachers and teaching institutions, it's impossible to say these were not proportionate to the circumstances and the inevitable, perhaps occasionally somewhat distractive requirements of the prison security regime. So that deals with the physical access, as it were, things coming in and communication, but it doesn't at any point deal with the point about the internet access to the course provision online, which had been denied. In paragraph 64, the ladyship distinguishes a case which I'll respectfully invite the court to give regard to, the Mehmet Arslan case. The claimant, as the defendants pointed out, in that case, those applicants were denied all access to a computer and internet, where that access was vital for the continuation of their higher education studies. In the present case, a number of initiatives and workarounds, including access to a non-OU tailored postgraduate course of study, have been put in place for the claimant. The fact that provision of and access to higher education may differ from what may be available outside prison is not evidence that it's unlawful and infringes the claimant's rights. Even though on occasions evidencing a clunky system and some management hiccups, books sent back when arriving without warning, need to use a social video slot from academic encounter, even taking the pictures including long out of time examples, the whole does not add up to a breach of the obligation to afford access to education to the claimant. So the learned judge, with respect, we submit, is taking a holistic global approach to deciding whether on a generalised, I might say slightly nebulous question, overall, is there a breach, but does not at any point ask whether there was a justification for restrictions upon the right being exercised that were imposed as a matter of choice or deliberately by the respondent. And we respectfully submit that on the authorities is not an adequate approach, because there needs to be, by the authorities and by the courts, the balancing exercise of whether or not the interference was proportionate to the aim that it sought to achieve. That's not achieved by a stand-back, generalised consideration. Do I, on a rather difficult test that may be to apply, do I or don't I, on an overall basis, decide that there was a breach, rather, of the obligation to afford access to education? She doesn't either use the term effective access, which is, even on the more generalised approach, at least we would submit to be considered.
Well, what do you mean by effective?
Well, that is, in some way could be the key.
What does the Strasbourg court mean by effective?
Well, my lord, that's where we must go when we look at the authorities, because in my respectful submission, what it means is more than just the fact you have access, as it were. So you can enrol on a course, that's enough. Effective access has a quality to it which requires one to consider whether A, there's an impairment of the right entirely, the impairment of the very essence of the right. You cannot do that even if you've got justification. Or secondly, you have a justified interference, you have an interference that doesn't impair with the right's very essence, but the question is whether it's a proportionate interference with the exercise of the right that is being undertaken. And one sees this in two lines of authorities, really. Those that are dealing with no access, those that are dealing with funding and resources questions, and then those that deal with specific restrictions, a third category, specific restrictions over internet access, which have been looked at by the court under both Article 2 Protocol 1 and Article 10 rubric. And the interrelationship between the two articles is also an important feature when those cases have been considered, and indeed more widely in the Velev cases as well. Sahim case. We'll come to those. But essentially my submission, respectfully, is that the learned judge has taken a globalised view without asking the question, were these restrictions that were imposed justified, and omits, in particular, the consideration of the university's online learning facility not being allowed. The learned judge goes on at 65 to refer to the list of accommodating strategies to make clear this was, in any event, not a picture of failure that produced a lack of access. Again, the word effective is missing, but a lack of access. Defendants have sought to remedy the issues that affected the claimant adversely personally within the necessary constraints of the regime. Strategies they use are comfortably adequate to afford him lawful access to education whilst in prison. It's unreal to expect there will be entirely hindrance-free learning, given the fact of the security imperative and reference to the IT policy. Now, with respect, that's not the claimant's case, that it's an expectation there should be hindrance-free. It's an expectation that if you are to give me less education, less access to my education facilities than another student because I'm in prison, that should be a justified interference. It's not asking any more than that. You may justify it by reference to a number of matters that the court would find to be relevant considerations and matters of discretion within the discretion of a decision maker. But what you must do is justify the restriction rather than have no justification and, on top of that, no compliance with what would have been the appropriate process under the policy, the IT policy, which is a general document. Generally, there's a public interest in securing the safety, preventing crime, ensuring that prisoners are not given inappropriate access or misusing access. But those generalised legitimate aims need to then be considered in the individual case in a balancing exercise where, on the other side, one is balancing the interests of education, the right of education. Now, regarding the Chromebook model, so that's what those are the three paragraphs of the learned judge's judgment dealing with the generalised restriction, as she puts it.
Yes.
One then goes forward to the Chromebook decision, which the court will find dealt with in the learned judge's decision from page 69 onwards.
Yes.
The first point is the unreasonableness in Wensbury terms, which she finds at paragraphs 80 and 81. Finding that there was a logically unsustainable conclusion reached. At 84, the learned judge mentions that once security issues were resolved, whilst they were being resolved, steps were taken to afford the claimant a degree of access to learning. And then refers to the fact that he obtained the qualification at the end of paragraph 84. At 86, the ladyship considers the implications for Article 2, Protocol 1 of the interruption to study, finding it did not amount to an interference. The delays couldn't be considered as constituting unjustifiable refusal of access to education. Again, the word effective is not part of the approach of the learned judge. And what she goes on to say is, furthermore, the evidence does not show that the absence of the Chromebook and new facility or IT access made study impossible during that time, excepted that it was more difficult. And respectfully, we submit that to set the level or the threshold for breach at the impossibility threshold or at simple access threshold is not sufficient in terms of the exercise of an important right recognised in Article 2, Protocol 1. And the citation given to Arslan there, paragraphs 58 and 59, which we'll see in that judgment, but the learned judge's consideration here ends with the general, at paragraph 59, the citation ending with Article 10 there, cannot be interpreted as imposing a general obligation to provide access to the internet or to specific internet sites for prisoners. The judgment, as we'll see, doesn't end there. The lack of a general right of access doesn't prevent the inquiry being, if there is such a provision, not being permitted access to it has to be justified by the proportionality exercise as one being conducted in relation to that restriction. So with respect, we submit the inquiry goes further and has to be conducted in accordance with the authorities further.
Is this the moment when you're going to start taking us to the authorities?
Yes, my Lord, just over the page 74, finally you see a general summary of conclusions, and just to point to the Roman numeral 2 aspect, the general restrictions on access challenge is rejected. The impediments to learning are generally not systemic nor policy-based. Particular operational difficulties generally mitigated. Where general differences exist, there are defensible reasons for the differences in access between the prison population and those not incarcerated. The difficulty with that is that it's generalised. One cannot say in general terms prisoners and students may have differences in their access. One has to consider why and whether necessary a particular difference must exist to deny the prisoner access to part of the educational facility. My Lord has invited me to move to the legal aspects, as it were, of the ground challenging Article 2, Protocol 1 application. Can I just point out, so at least the court has reference to where it is. I've mentioned applications that were being made from May through to August 2022 for access to the university campus website. We have the applications, either general applications or complaint comp forms, submitted in the supplemental bundle, page 169 through to 172. In each case, it's item 1. There's a list of things that he's presently restricted from. Can I just give an example, just with one page of those? But page 169, please. In the supplemental bundle, and you'll see in the general application form, number 1 was I would like to get my university website added to my virtual campus account, please. It gives the website address. That request is repeated on each of the following complaints or applications that are made. It's referred to on 174 as the University VOE webpage, virtual learning facility, and at all points these requests are met by we'll look into it, or we'll come back to you when someone else has come back to me. But throughout the entirety of the position, we only reached the evidence that I showed you earlier in paragraph 45 of Miss Anderson's statement, which is that it was being looked into as the claim came to hearing. It hadn't got any further than that. So those are the background areas and the way in which we respectfully submit the learned judge has erred in the approach. Now, to demonstrate that, in terms of the law, it's set out within the ladyship's judgment.
Well, sorry, it's always interesting to look at the actual facts. You just showed us page 169 and the reply on 170.
Yes.
Just focus on it. There are more, no doubt, but wouldn't say, would you, that at the stage of the 1st of June, that that reply to 169 involved a breach of Mr. Ellis's A2, P1 rights.
No, and that's.
But you say it goes on and on. And at what point are his ECHR rights being contravened?
After a reasonable period has expired in which one would expect them to have answered the point, considered it. I can't point to a specific date because they never actually make a decision. They never actually come to deal with it. So that one has to fall back on what would be regarded as being reasonable, given the need to conduct the exercise. And this was the point of the law. The only point of the domestic law I was going to invite the court's attention to is the IT policy, which was mentioned.
Yes.
Which you'll see on page 58 within the judgment. It's also in the supplemental bundle, in fact, because it's part of the exhibits of Miss Anderson. But whichever location, if it's more convenient for the court in the judgment.
Yes.
That's on page 58 of the core bundle. Paragraph 16.9. Provides the accessibility of learning materials by prisoners in custody must be balanced against security considerations. Access to the internet will only be granted following a thorough risk assessment on a case-by-case basis of the system, hardware, software and connectivity. Prisoners' access to IT whilst in custody subject to an individual assessment. As per the National Security Framework, advice on appropriate access controls can be obtained from the Security Group, the IPA team. The reference within that to the balancing and the assessment case-by-case. The references to assessment are repeated also at paragraph 16.11, must be risk assessed. And prisoners must be subject to an individual risk assessment at 16.12. Now, there are other provisions of the domestic law in terms of the requirement to encourage prisoners in their studies and to provide reasonable facilities and the like. But ultimately, this is a question of restriction of access to a website, IT facility, and this is the closest one sees within policy, which is that there is a potential legitimate aim to restrict access for security purposes so that you're avoiding prevention of crime, for example, protection of others. But those assessments are not, as it were, in stone or done generally. They are individual. They look at the individual access that is concerned and the individual accessing it to determine whether or not it is permitted. So in the domestic sphere, there's no restriction on this website existing, of course, as a lawful website. There's no restriction no ban in law on prisoners receiving it. The question is whether or not on the individualised assessment there is justification for withholding access to it or not, applying the balancing exercise that is a right to education as opposed to, and that IT policy of course covers other rights information-wise, but rights to education versus rights to security concerns being, or rather, what balances security concerns, legitimate in deciding whether or not you would give access. Now, and as I say, that failure continued throughout the educational programme, including after those requests, and that there's reference to that having been referred to on many occasions. We've got those particular records that indicate those particular occasions of request and answer in formality, in a written sense. Ground one, having seen the way in which the learned judge has addressed matters, respectfully we submit the threshold for an infringement is met by a restriction that interferes with or removes the access to part of the education, the effective access to the available educational provision without positive justification for that restriction. The limitations experienced by the appellant...
Sorry, what are you reading from?
I'm just making the general submission. I'll take you to the cases. Sorry, my apologies. Right. So my submission that I will seek to make good from the authorities is that the limitations experienced by the appellant did not meet the requirements that each must be foreseeable, firstly. Secondly, in pursuit of a legitimate aim. And thirdly, proportionate to the pursuit of that aim. We respectfully submit that the third is further and is independent of any question of irreducible minimum. So the impairment of the very essence of a right, one's familiar with that in different types of situations. I'll come back to in a moment, but let me first deal with some of the authorities and specifically what they say. The Mehmet Arslan case is a useful starting point. That's our tab 27 of the authorities. Page 857, the court has tabs. This case concerns 2 life sentence prisoners who sought access to the use of computers and internet for higher education studies. And the court ultimately finds there is a violation of Article 2, Protocol 1 in the denial of access. It's useful to start, I think, at page 867. And consideration of the scope of Article 2. Before we turn to that, paragraph 42 on page 867, it's relevant that the court felt one can simply choose being master of characterisation in law to the facts of the case, how best to assess this particular complaint, because the elements of it, of course, overlap. Access to the internet by any individual has the capacity of engaging their rights in Articles 8 in particular and Article 10 in particular. And we'll see in a moment that some of the cases the European Court has decided under the rubric of Article 10 rather than under Article 2, Protocol 1, even though essentially the factual scenario, the factual complaint is the same. In this case, the complaints were wide-ranging. You can see from the top of page 867, complaints of Articles 10 and 8 were within a large number. The court observes the complaint concerns the inability to use a computer and to gain access to the internet in prison. It notes 2 cases which I also rely upon, Calder and Estonia and Yankovsky and Lithuania, in which there had been complaints dealt with under Article 10. The court, in the last few lines of that paragraph, says, being master of the characterisation to be given in law to the facts of the case, the court considers the applicant's allegations should be assessed in light of the first sentence of Article 2 of Protocol 1. No person shall be denied the right to education. So from this one can see expressly that the court is not considering that there is a difference in substance in how one evaluates a restriction imposed, whether on Article 2, Protocol 1 route being your chosen heading, as it were, or Article 10. That's in keeping with the usual approach to justification for restrictions and interferences occurring. Now, there's some consideration on the facts that the court needs to give, as is said by the respondent. The court refers to the applicant's case that it was vital for their continuation of their studies. Now, that word in itself doesn't mean necessarily without which it cannot occur at all, vital being certainly a significant part of it. But even if in this particular set of facts one talks about being unable to do it without, when we come to the application of this case and approach in other cases, that hasn't been suggested to be a threshold, as it were, that is of legal significance. The question here, the court goes on over at page 869 to a apply the Sahin and Turkey case, one can see there that this right applies at higher educational levels. That's the bottom of paragraph 51 on page 869. The court is talking here, as we can see from the higher up fifth line of that paragraph, obligation to afford effective access to the existing establishment. Then paragraph 55 makes the point that I've sought to place reliance upon, that all prisoners in general continue to enjoy all their fundamental rights. And the court, having made that point, obviously accepts Article 5, because a court has already decided that right must be removed or restricted. But then it goes on over the page to talk about other rights, including freedom of expression, etc., access to a court or lawyer. Any restrictions on these rights must be justified, but the justification may well be found in considerations of security. So you can rely on security that you require around a prisoner, different to requirements you may have about a non-prisoner, but it doesn't mean that their rights are not there to justify any restriction there too. And within those judgments, the court will also note reference to Velio-Velev in Bulgaria, which is another case we'll come to. But then there's citation at 56 and 57 of dicta that one also sees in the Velio-Velev case. As we're starting with this case, I'll deal with it here. Towards the middle of we'll start at the top of paragraph 56. As regards the right to education, it's not absolute, may be subject to limitations. An absolute right, of course, like Article 3, cannot be subject to restrictions. Most rights, Article 8, 10, etc., are capable of restriction. The court regards this right as such. Provided that there is no injury to the substance of the right, these limitations are permitted by implication, since the right of access calls for regulation by the state. So this is the concept of the irreducible minimum. You can have restrictions provided they don't interfere, no injury to the substance of the right. In order to ensure the restrictions imposed do not curtail the right in question to such an extent as to impair its very essence and deprive it of its effectiveness, the court must satisfy itself they are foreseeable and pursue a legitimate aim. First two elements to any approach. The difference with Article 8 to 11 being it's not an exhaustive list of legitimate aims, it can be a wider list in Article 2, Protocol 1. That may well be in reference to resourcing taking a slightly different approach if you're talking about positive resourcing obligations under Article 2, Protocol 1. But the court then importantly goes on to this. Furthermore, a limitation will be compatible with Article 2 of Protocol 1 only if there is a reasonable relationship of proportionality between the means employed and the aim sought to be achieved. So that is the additional threshold that has to be when you're talking about a restriction imposed on the exercise of the right, there is a limitation upon what is permissible restriction, and it is to justify that as proportionate.
Well, there's a fairly familiar list of phrases, at least familiar to me from such Strasbourg case laws I've come across. And you point to a reasonable relationship of proportionality and so on. Ms. Taylor will no doubt emphasise such an extent as to impair its very essence and deprive it of its effectiveness.
Yes, and ultimately, my lord, I think that may sum up the dispute between the parties. The respondent's case, as I understand it, is you are limited to a consideration. Was there an impairment of the very essence of the right, in which case breach? If not, doesn't matter whether any restrictions were unjustified, you haven't reached the threshold for a breach. So there's only, on the respondent's case, as I understand it, one threshold for a breach. And if you don't get past that stage, you don't ask any questions about justification. The appellant's case is that is a misreading of the approach and would create a complete disharmony between Article 2, Protocol 1 and the other rights that are capable of attenuation, the others that have permissible, not absolute, permissible exception. Because it would mean in the reality, anybody who's suffering the type of complaint that the appellant makes would simply have to dress up their educational concern under a different heading, because you would have to rely on, say, Article 10 or Article 8 rather than Article 2, Protocol 1, on the basis that there's some limited threshold, which is that the very essence has to be impaired on a global approach to Article 2, Protocol 1. But you could legitimately complain on Article 8 or 10 grounds that you've had an unjustified restriction with the exercise of your rights that have encompassed in your private or family life or your expression. And bearing in mind, I say importantly, where I started with this case, the interchangeability that we'll see between Article 10 and Article 2, Protocol 1, when you're talking about restrictions, for example, to internet access to a site that happens in the particular case to be an educational purpose, it matters not to the European Court whether you talk about Article 2, Protocol 1 or Article 10. And that's important because it's that harmony, which we'll see express reference to in a moment, but that harmony that the court is trying to provide in relation to how one is addressing these convention rights. The right to education not being peculiarly less capable of requiring a state authority interfering with the exercise of the right to justify that interference or that different treatment.
So I understood it that you say that for any restriction there are two tests. Firstly, it must not impair the very essence and deprive the right of access of its effectiveness. But even if you get over that, you then have to go through, does it pursue a legitimate aim, is it foreseeable, set down by law, and is it proportionate? Yes.
We're assuming, of course, we're talking about a restriction that goes to the education that you're receiving. But yes, that would be an interference that needs to be justified. You're exercising your right. And that follows with respect from the word furthermore. It's not part of one test. It's a question posed. A limitation will only be compatible if there's a reasonable relation of proportionality. And then when we see this being applied in a moment, it's being applied to the specifics. So it's not a generalised question where you can simply say there is a security justification that may or may not apply. So we point to that. You have to think about that in terms of deciding whether or not this restriction is to be maintained as an authority, and the courts also have to grapple with that. So that's where these cases will take us from this starting point of the furthermore. Proportionality is an exercise, and it doesn't matter whether you're in Article 10 or Article 2 Protocol 1 rubric. Now, the court goes on to apply these tests in that case, but we can see at paragraph 58 over the page, the court again, following the Velev decision, refers in the middle there to present complaints concern the refusal to them of access to a pre-existing educational institution, namely the possibility of using a computer and internet, as well as other electronic and audio-visual facilities aimed at training and education, which were vital for the continuation of their higher education and the furtherance of their general knowledge. As noted above, right of access to pre-existing institutions falls within the scope. Any limitation on this right has therefore to be foreseeable, to pursue a legitimate aim, and to be proportionate to that aim. And although there's no positive obligation to provide education, where such a possibility is available, it should not be subject to arbitrary and unreasonable restrictions. So all of that terminology, as the court will immediately recognise, is appropriate to those rights where proportionality is an exercise, arbitrariness and unreasonable restrictions, meaning unnecessary, disproportionate restrictions. Now, finally, the court notes at 59, and this is important, that the restriction on the right to education was based on the rejection of requests to be allowed to use the computer and access the internet to continue chosen studies. basically, therefore, they're not being allowed to request admission to an existing educational programme of their choosing. In assessing the applicant's complaint, the court will take due account of its case law, hitherto developed under Article 10 of the Convention, on the rights of prisoners to internet access. See Calder and Jankowski cited above. That case law shows that in order to determine whether a refusal to provide prisoners with internet access is justified in a given case, an assessment should be made of whether domestic courts conducted an adequate evaluation of the actual risks to security inherent in the particular case, thus properly balancing the competing interests. That is what we respectfully submit is required following the law as identified here, and is missing in the respondent's factual approach here. In applying that assessment on page 873, and the court then talks again about Calder and Jankowski in the end of the paragraph we were on. Moving on to paragraph 61, as regards the proportionality principle, the court will assess the reasons given by the national courts and the government to justify the impugned restriction. So the reasons for the restriction had to be considered and weighed up for proportionality to determine whether relevant and sufficient, whether the measure was proportionate to the legitimate aim pursued, having regard to the requisite fair balance between the right to education and the arguments advanced in rejection of the request. There's very much the individualised assessment one's used to in Article 10 or Article 8 scenario where considering a justification. The court, at paragraph 64, then references the approach differently, of course, between the European Court and the domestic courts, but was concerned as to whether the domestic courts had carried out the requisite balancing of competing interests to prevent any abuse on the authorities' part implementing relevant domestic rules. In the particular case, at paragraph 65, towards the end, the court held there was no practical justification relating to a lack of resources in the prisons was given during the domestic proceedings before the court. So one can have regard to things like resourcing within and security within reasons that might be given in this context, but that hadn't been presented in evidential justification at the time. And paragraph 69 again is the application of the case law of Velov, Calder and Jankowski, with the court reiterating that the manner and means of regulating within the state's margin of appreciation, and even though the security considerations advanced by the national authorities and the government might be considered relevant in the present case, it observes, as in the cases of Calder and Jankowski, the domestic courts conducted no detailed analysis of the security risks and failed on the one hand to conduct the requisite exercise of balancing the different competing interests in the present case and fulfilling the obligation to prevent abuse on the authorities' part. So under that condition, the court wasn't convinced sufficient arguments had been advanced to justify the rejection of the requests made under the law. And the court at paragraph 70 also refers to its established case law on the balancing of competing interests, which I think is a reference there to the proportionality test. This is a case where, as the court final point to note, paragraph 78, the court will see that there was a finding of violation sufficient just satisfaction. So the respectful submission we make in relation to this case is that the learned judge hasn't undertaken that exercise we've just seen and required the justification to be provided for the restriction on access to the internet, particular educational provision. I mentioned the question of the very essence of a right arising in other examples. One that we'll see Miss Mountfield, King's Counsel, has presented to the courts previously relates to Article 6, but others are Article 10, Article 11 protest rights, where the European Court speaks of not being able to have measures in place that impair the very essence, as well as individual cases where the justification for proportionality has to be made out for a decision to, for example, prosecute an individual or take another measure. So the two aren't exclusive in other contexts, and in my submission they're not exclusive in this context as concepts. One is an irreducible minimum through which the right operates. The other is concerned with justification for interferences that the state has a deliberate choice to make, a variable decision to make in relation to an existing provision which it is restricting access to. And so, with respect to Melina Friend's submission in her skeleton, that the right engaged here of Article 2, Protocol 1 is different from and does not speak, the Article 10 jurisprudence is different from and does not speak to this right, I respectfully take issue with, on the basis that what the court appears to be saying and doing is there is harmony in the approach between restrictions, whether or not we use the lens of Article 2 Protocol 1 because it happens to be educational, or whether we use the lens of Article 10 because it's a wider form of information, or we've chosen to do that as a matter of choice. There isn't substantial difference in what we're talking about, and the court doesn't demur from asking for justification for a restriction that is imposed on the exercise of that right. Other examples that go to this point, and also the principles of proportionality being applied, are the Calder and Estonia case, tab 26, please. This is a case in which a prisoner wished to be granted access to information on the internet on 3 particular websites. These were not directly concerned with education. These were legal websites, government websites. And so the court deals with this through the lens of Article 10, and it finds a breach applying a proportionality test, and as we've seen just referred to in the Article 2 Protocol 1 context in the Mehmet Arslan case. To go through to principles, page 850, paragraph 44, the court refers to the internet playing an important role, enhancing access to news and information. Now, at 45, whilst this isn't an Article 2 Protocol 1 case, it's precisely the same terms. Article 10 cannot be interpreted as imposing a general obligation to provide access to the internet or to specific internet sites. This is towards the bottom of paragraph 45 on page 850. No general right from Article 10. And that's the same, as you'll recall, Her Ladyship ended paragraph 59 of Mehmet Arslan with. But it went on, didn't it, but in the context here, you've got to justify the interference with what does exist and what is available. And it's the same in Article 10 as in Article 2 Protocol 1, because here it says, the court, despite there no general obligation, finds in the circumstances of the case, since access to certain sites containing legal information is granted under the law, the restriction of access must also, that contains legal information constitutes an interference with the right to receive information. And then it moves on to apply the familiar proportionality test, and does so, asking whether the interference was necessary at paragraph 48, referencing possible security issues, but the issue being whether or not there had been justification for those security issues being made out. At paragraph 52 on page 852, the court again doesn't ignore the public service value of the internet, its importance for enjoyment of a range of human rights. So the internet, of course, will be a crossover feature then in the human rights applications. And at 53, while in the middle of the page, just above letter F, while the security and economic considerations cited by the domestic authorities may be considered as relevant, the court notes the domestic courts undertook no detailed analysis as to the security risks allegedly emerging from the access to the 3 additional websites in question, and having regard to the fact these were websites of state authorities and international organisation. So the generalised approach wasn't sufficient. There had to be an individual balancing exercise to consider. The court would have expected detailed analysis. And paragraph 58, sufficient just satisfaction to find the violation. The authority Calder is referenced also in another decision on Article 10, the Ramazan Demir case, tab 29, sorry, page 900. This is a summary of the case available from the European Court because the original text is not in English. It's a consideration under Article 10 where, again, the complaint seems to be in the middle of page 900, the third paragraph, in restricting the access to the internet sites in question. National courts' decisions seem to be based primarily on the provisions of Turkish law. However, the national courts did not provide sufficient explanation as to why the applicant's access to these internet sites could not be considered as relating to his training and rehabilitation. So the individualised assessment being missing in that case led to a violation of Article 10 and the award of €1,500 on page 901. Now, the other case that gives us a little bit more detail is the case Mehmet Arslan refers to of Yankovsky, tab 28. This case concerned a prisoner who wished to acquire a second university degree, who complained of restricted access to the website of the Ministry of Education and Science, preventing him from receiving education-related information.
I'm so sorry, I'm behind you.
I'm sorry, Lord. Tab 28, please.
Thank you. Yes.
So this is the Yankovsky and, if I pronounce it correctly, and Lithuania case. As I said, it's a prisoner who's seeking to acquire a second university degree, so higher education. Complaint is of restricted access to the website of the Ministry of Education and Science, preventing him receiving education-related information. Now, this is a complaint which, contrary to Mehmet Arslan, is dealt with under Article 10, but is the education-related information. We see that at paragraph 37 on bottom of page 889. And then the court's approach is to consider the government had provided some asserted arguments, justifications in paragraph 45 on page 891. It was aimed at preventing crime, prohibition of internet access aimed at preventing crime. And at 46, the government argued for alternatives. Now, this is of interest because at paragraph 46, the government's arguing the internet's not the only way to get the information. So there were resourcing issues if there was to be the attempt to allow the access in this way, but he said that he could effectively exercise the right by other means such as postal correspondence or letters, and the information was available in various forms, announced in the press, scheduled publications are printed. Such information could have been imparted by his relatives and may receive information in the prison units themselves. So the government was essentially arguing in the round on an approach that's holistic. We're saying that we haven't impaired the right. There is a provision alternatively available. So it wasn't a case where it was vital that there could only be access through this means. But there were complaints nonetheless that this was a means that was more effective for the individual or more helpful. And at paragraph 53, on the existence of an interference, the court notes on page 893 at the bottom that the applicant's request concerned information that was freely available in the public domain. His complaint concerns a particular means of accessing the information in question, namely that he as a prisoner wished to be granted access, specifically via the internet, to the information published on the website belonging to the Ministry of Education and Science. And the question for the court at 55 is answered that this is an interference. The act of not allowing the prisoner to access the educational material online is an interference. And that access to information relating to education is granted under the law. The court is ready to accept the restriction of access to the internet site constituting interference with the right to receive information. Now, that approach, whether we call it Article 10 or Article 2, Protocol 1, identifies that you're exercising that right, whether it's freedom to receive information or whether it's your educational right, and you are being restricted in that exercise, and that's leading us on to the question of whether it's justified. And the court, at page 895, you can see from the Roman numeral 3, is asking whether the interference was necessary in a democratic society. It's accepted that it was serving a legitimate aim, question being whether it's proportionate. And at 61, the court deals with, turning to the Lithuanian authorities' decisions, the court cannot but observe they essentially focused on the legal ban for prisoners having internet access as such, instead of examining the argument that access to a particular website was necessary for his education. Goes on to talk about his wish to acquire a second university degree, and noting that prison authorities or the courts do not even go as far as to argue that extended internet access could incur additional costs for the state. Whilst the security considerations arising from prisoners' access to internet as such, and cited by the prison authorities, may be considered relevant, the court notes that domestic courts failed to give any kind of consideration to the fact that the applicant asked for access to a website created and administered by the Ministry of Education as a state institution. The courts were were completely silent on the matter of education. So, although it's an Article 10 case, the obvious connection with Article 2, Protocol 1 is express, and in keeping with the concept in Mehmet Arslan that it doesn't matter which lens you're using, the question is still ultimately seeking the justification. And the court went on at 62 to talk about the particular importance the internet plays, and the absence of, at the bottom, noteworthy, the Lithuanian authorities did not even consider a possibility of granting limited or controlled internet access to this particular website, which could hardly have posed a security risk. In these circumstances, the court wasn't persuaded sufficient reasons to justify the interference had been put forward, and there was a violation of Article 10, for which just satisfaction was the violation finding itself, paragraph 70. And my lords, those cases, we respectfully submit, form a line of jurisprudence from the Strasbourg court, which is clear and constant, where you have a situation where the prisoner is seeking access to a website for educational purposes, and therefore on the Uller approach is one that is required to be taken into account by the court under Section 2 of the Human Rights Act, and you have that in the written submissions. Skeleton 43, paragraph 43. Now, so far as the further case law is concerned, this includes cases on restriction of the right, and in particular, Grand Chamber decision of Sahin and Turkey, which I'll next go to, please, at tab 23. The issue that reached the Grand Chamber there was a complaint under various articles, including Article 2, Protocol 1, but not only. But the central point was the same in all those complaints. It was the ban on wearing a headscarf in the university. And so one of the principal articles relied upon was Article 9. Another was Article 2, Protocol 1. And for good measure, she'd also relied on Articles 8 and 10. So, as one often sees, there is a case in which a number of articles have been relied upon, but the central complaint is the one factual concern. And the court deals with those in relation to Article 2, Protocol 1, at paragraph 134 on page 744. of the authorities, tab 23, 744. The first point at 134 is to recognise that the right of Article 2 Protocol 1 applied to tertiary education. That's mentioned in a number of the cases, but as it's a Grand Chamber decision, it's worth noting this is often cited as the source. Then one has at 136 reference to the development of the right to education, and the court noting it's of crucial importance the Convention is interpreted and applied in a manner which renders its rights practical and effective, not theoretical and illusory. Again, this is standard fare, as it were, one sees in the jurisprudence of the court. But it is important that it's applying that in Grand Chamber, in this case in 2007, to this right, to the way in which one's to interpret and apply Article 2, Protocol 1, being a practical and effective right. And it also has regard to the crossover with other rights, not surprising, of course, because it's a case where the court has many rights cited to it and has to decide which is the appropriate to proceed with and how they interrelate. Now, on page 748, the general principles, paragraph 152, notes that access constitutes only part of the right to education. Third and fourth line of 152. And similarly implicit, this is the end of that paragraph, similarly implicit in the phrase, no person shall, is the principle of equality of treatment of all citizens in the exercise of their right to education. So it's implicit within the right itself that there's equality of treatment.
Do you accept the passage it applies in paragraph 152 in parenthesis there, that the beneficiary should have the possibility of drawing profit from the education, that is to say the right to obtain in conformity with the rules in one form or another education?
My Lord, that's taken from the Belgian linguistics case, as my Lord knows. The implication of any one form or another, I'm not quite understanding my Lord's question to me.
Right.
Apologies.
I mean, your complaint, or the complaint of the appellant here, is in relation to the effective access to the internet, but in this particular case, arrangements were made for him to obtain education in alternative ways whilst the investigations are being undertaken. So does the phrase in one form or another make any difference to your case here now?
Not on my reading of what the court was saying there, and partly because I'm not yet divorcing in my head where the court was talking about the official recognition. There was an issue in that case about whether you, after the studies had been completed, there was a system for converting the educational pass, as it were, into a recognised degree or not recognised degree.
Yes.
And one of the issues that was of concern to the applicants in that case was that if it were the wrong language to use the shorthand, but if it were in that situation, they wouldn't obtain the official recognition, and that lack of official recognition would prevent them from using the degree, for example, for the legal profession or other professions. And it may not be that it's in reference to that official recognition, but it's in conformity with the rules in force in each state in one form or another.
Right.
I'm not clear where the court's putting that. Perhaps we might learn more from seeing it in its context, but for the present purpose, if I may say this, what my submission amounts to is that one doesn't need to read into the jurisprudence, one needs to apply the jurisprudence, which we now have. So we've moved on through these cases to a position where I would point the court to the approach that says you don't just ask, have you impaired the very essence of the right, but you have a nuanced approach which asks, that's obviously unacceptable, but also if you've imposed a restriction on available, and I accept the point that one doesn't use Article 2 Protocol 1 to create positive obligation to create a school, for example, but it doesn't require the creation of an educational institution, but if you have an educational facility there, restricting access to it is what the right's really concerned with. And that restriction can be complete denial of access. Yes, that would be the very essence of the right. But that doesn't necessarily have to be the only thing that the right protects. In the same way Article 10 would protect, you have the protection of effective access extending to access which you're not unjustifiably restricted from of an existing part of the course you're undertaking or the facility, educational facility you're seeking to access. So what the court is saying in this case, in the Grand Chamber's case, is it's using the this more nuanced approach in my submission, where one goes on to see on page 749, at the top there, we have this term, furthermore, a limitation will only be compatible with Article 2, Protocol 1 if there's a reasonable relation with proportionality. So that has the Grand Chamber seal, as it were, applied on page 749, and it goes on in the next paragraph to assist with the need for the harmony between the different provisions when one's talking about the factual scenario here. So 155, such restrictions must not conflict with other rights enshrined in the Convention and its protocol either. That's not the same question that's just been posed about proportionality, but it is a recognition that shouldn't either infringe with those. And that the provisions of the Convention and its protocols must be considered as a whole, and accordingly, the first sentence of Article 2, where appropriate, must be read in the light in particular of Articles 8, 9 and 10 of the Convention. So the Grand Chamber isn't saying it really is important to whether a claim succeeds or not, whether you've chosen to say Article 2, Protocol 1 because you regarded it as your educational right you were exercising, or whether you've said it's Article 8 or Article 10 instead. The approach is going to be a harmonious one in which proportionality has been recognised, and the reading of Article 2's first sentence is in light of those other rights you have, Article 8, 9 and 10 in particular. So in that particular case, the court then applies that proportionality question, paragraph 159, and you can see there, of course, it's applying that in a different paragraph as a different aspect of the test to be satisfied of from those which precede it in the earlier paragraphs. Now, because there had been, in that case, the reasonable relation of proportionality, it didn't matter whether it was Article 9 or whether it was Article 2, Protocol 1, the same result had to follow. Same assessment of balancing interests has been conducted. There's one paragraph, please, which I'll take the court to in the next case, tab 24, page 760 onwards. The Katan and Moldova and Russia case at page 803. It's a case which is very different on its facts from the type of restrictions that we were looking at in terms of the other cases, but it does make the point, as the Grand Chamber just has, about reading this provision, Article 2, Protocol 1, to promote internal consistency and harmony between the provisions of the Convention. So that's paragraph 136 on page 803, where there was an Article 2, Protocol 1 breach on the part of Russia. In particular, again, these need for harmony between Article 8, 10 and that. And there's also reference to the practical and effective application of the right, going over the page at the end of 136. Now, to then look at those cases in the domestic sphere, which have looked at the European cases. In fact, I think I haven't yet taken the court to the Velev and Bulgaria case, which I should just complete the European jurisprudence with that. Tab 25, page 822, please. This was an Article 2, Protocol 1 complaint by a prisoner who was not enrolled in a school in the prison and complained about that decision. The court's assessment of the complaint is on page 833 following. It began by underlying prisoners in general continuing to enjoy all fundamental rights and freedoms under the Convention. It notes those other rights and notes any restrictions on those other rights next to letter C from 833. Any restrictions on those other rights require to be justified, although such justification may well be found in the considerations of security. It notes at the bottom the Sahin case applying to high levels of education as well. Then it uses the usual terms that we see at paragraph 32 there, of not having restrictions that curtail the right to the extent of impairing its very essence and depriving of its effectiveness, and then furthermore, a limitation achieved of proportionality. The court finds the breach here, finds that the limitation at paragraph 34 on page 834. Paragraph 33 deals with the importance of the internet. No, it doesn't. It deals with the importance of the right to education. I apologise. So 33, underlining how important the right to education is. Unlike some other public services, it is a right enjoying direct protection under the Convention. So it's certainly no lesser than things that come within Article 8. This is a specifically protected right of education. And then at 34, towards letter E, as noted above, the right of access to pre-existing educational institutions falls within the scope. Any limitation on the right had therefore to be foreseeable, to pursue a legitimate aim, and to be proportionate to that aim. And it's citing there paragraph 32 above, which is the terms we've seen replicated many times in terms of how one has those three elements. Although Article 2, back to paragraph 34, bottom, although Article 2 of the first protocol does not impose a positive obligation to provide education in prison in all circumstances, where such a possibility is available, it should not be subject to arbitrary and unreasonable restrictions. And the court then moves on to consider those different elements to the test, and it evaluates the strengths. Paragraph 37 onwards, it's looking at the government's three grounds for the justifying that were alleged to justify the restriction, and it rejects those grounds on an evaluation of the proportionality or necessity of them. It finds those grounds lacking on a detailed analysis. So this is the approach that is being taken, not a sort of stand back and look at what is or isn't available in terms of education, but you're restricting a possibly available existing educational provision, and in restricting access to that, is there a justification? And it looks at the question of justification and mentions also resources at letter G to H. It was said that remand prisoners might not be there in time to take up the courses, therefore it would be a waste of resources. And the court said the government provided no statistical information as regards availability of resources at the school to justify, for example, a policy of concentrating limited resources on the prisoners serving the longer sentences. So resources could be an issue in a case which concerns Article 2, Protocol 1, but it would have to be such as to justify, it would have to be evidence that justified that that was a balancing, preferable consideration balanced against the right that it restricts. And at 42, summing up, the court found the government had provided neither practical reasons based on resources, for example, nor a clear explanation of the legal grounds for the restriction placed on the applicant. So it finds a violation of Article 2, Protocol 1. In that particular case, there was a requirement for damages for just satisfaction. At paragraph 53, €2,000 was awarded to that particular applicant. Now that, I think, does complete the European case law, and I then would compare that to the domestic cases that we so far have. To deal with them in order, it perhaps makes sense to start with the 2006 Lord Grey school case and work forwards. Tab 6, page 84, is the beginning of that case, and two particular of their lordships' judgments that have been looked at by the later authorities. This was a case in which it was found one can expel a pupil for good reason, but need to make alternative provision. In that context, one has first Lord Bingham's dicta at paragraph 12 on page 94 to 95. His Lordship noting the Sahin and Turkey case, Grand Chamber case. And then at paragraph 24 on page 100, his Lordship made observations about the right in Article 2, Protocol 1. It's intended to guarantee fair and non-discriminatory access to that system by those within the jurisdiction of the state. So again, his Lordship would seem to agree with the equal treatment, non-discriminatory access element within the article, or certainly its purpose. The fundamental importance of education was recognised. But he says the guarantee, in comparison with most other convention guarantees, is deliberately a weak one. There's no right to education of a particular kind or quality other than that prevailing in the state. There's the difference between those obligations where positive obligations to provide a system, to provide something, arise under Article 2, 3, something like Article 8. But here, in the Article 2 Protocol 1 basis, as we know from the case law, there's no obligation to create something that doesn't exist. It's much more concerned with access to what does exist. And the convention guarantee of compliance with domestic law is not within this. And that binds my approach in relation to whether I can submit that it could follow from one to another. There's no convention guarantee of education uttered by a particular institution, and so expelling the pupil was permissible unless there's no alternative source of state education open to the pupil. So that's a type of irreducible minimum. If there's no education at all, you couldn't even expel, even if you had good reasons for the expelling. Then his Lordship said this: the test, as always under the convention, is a highly pragmatic one to be applied to the specific facts of the case. Have the authorities of the state acted so as to deny to a pupil effective access to such educational facilities as the state provides for such pupils? In this case, attention must be focused on the school as the only public authority being sued. But that dicta doesn't, as one can see, elaborate upon an approach to that question. It rather begs the question as to what is effective access to the same educational facilities provided for others studying the same. There wasn't any suggestion to the negative in terms of the Sahin and Turkey case, for example, or dicta that the European Court has used to express things in its way. And of course, it's a right expressed in Europe, which we attempt domestically to apply and interpret in accordance with the Convention and the approach of the Strasbourg Court in accordance with the Court's duties. But so, whilst noting his Lordship's dicta, my respectful submission would be that one doesn't treat or read it as if it's a statute or as if it's a elaborate explanation of the test to be applied in all circumstances, rather than consideration of the case and the issues before the court, and a very shorthand question. Lord Hoffman has also made some remarks that the later authorities consider, particularly paragraph 57 on page 107, where his lordship speaks there about such procedures as would be involved in denying entry or expelling from a particular educational establishment. Those procedures may be relevant to rights under other articles such as 6 or 14, but Article 2 of the first protocol is concerned only with results. Was the applicant denied the basic minimum of education available under the domestic system? That may be a source as to why systems is some consideration in some of the authorities, or perhaps even in the references that the learned judge below made. But later authority of the highest court says that we don't read this as particularly, or as being different in test to that which Lord Bingham says, and use Lord Bingham's dicta as the perhaps more useful. On paragraph 60, page 108, Lord Hoffman again says that it's not a breach of Article 1, as Article 2, Protocol 1, if there's a breach of domestic law. And he considered at 61, above letter F, it would have required a systemic failure of the educational system, which resulted in the respondent not having access to a minimum level of education. And as there was no such failure, that was the end of the matter as far as his lordship was concerned. Now those dicta, those judgments were considered at length in the next case, which is that of A and Essex County Council, which is the tab 8, page 180 onwards decision. This was concerned with a strikeout of a claim for Article 2, Protocol 1 based on delay in a child with special educational needs accessing a school appropriate to those needs, or accessing education to in any form appropriate to those needs. And my respectful submission is that the dicta here and the result of the majority, and it was a split decision, indicates that there was concern about the reasonableness of steps being taken to facilitate the educational provision, and ultimately the reason that the case should not have been struck out and was reinstated by the majority was on consideration of whether or not there was more that the local authority could have done. In essence, a test of reasonable action, not simply looking at the objective outcome or result, as it were you or weren't you in education for this period of time, but as it was that as a result of unjustifiable state inaction or state failure, rather than justifiable state attempts to obtain the educational provision that we needed. So I'll take these dicta in a little bit of detail because I think they're useful to the court in considering this. So Lord Clark, firstly, in the dissent on the result, but at page 191, there was general consensus on the point as to whether or not there was a difference between Lord Bingham and Lord Hoffman in the dicta that we've just seen. Paragraph 12 and onwards, Lord Clark didn't find there to be a difference in the principles stated by Lord Bingham, and that is also the position, without skipping around into the different judgments, also the position of Lord Brown at paragraph 129. Now, in the application in which Lord Clark was in the minority and dissented, paragraph 45, he having referred to Lord Bingham's dicta at paragraph 20, of interest, sorry, on page 192, bottom of paragraph 17, the dicta from the Belgian linguistic case being summarised not to conflict with other rights enshrined in the Convention. He regarded those principles as the same as those summarised in paragraph 24 of Lord Bingham's speech. And then in the dissenting aspect, his lordship at paragraphs 45 and 55 was questioning where there had been the delay, looking instead at the wider picture, not just the period of delay, even if the authority might be more generally open to criticism for not doing more. So he wouldn't have remitted the case for a trial on the possible liability on the basis that at paragraph 55, page 201, it wouldn't have mattered whether or not there were unjustifiable aspects to the conduct, but the majority found that that was relevant. Lord Phillips in the majority is the next judgment. Paragraph 85, going through to page 209. His lordship set out Lord Bingham's dicta at paragraph 24 over at 78, across the page, and then applying Article 2, Article 1 here, at 84, 85, same point that domestic law failing doesn't automatically breach Article 2, Protocol 1. There was regard at 86 to be had to limited resources. The needs and resources were considerations. And at paragraph 89, there was a question that might be dependent upon the facts, for saying that during this 18-month period, the applicant was deprived of such educational provision as could have been made available, and that deprivation violated Article 2. So, depriving of education that could be available when it was avoidable, unjustifiably, was part of the reason why one would have to try the matter to see whether or not the justification was there. His lordship at 91 says that Lord Hoffman's dicta are not of general application. Is the minimum level of education. If there was no such failure, that's the end of the matter. So the approach that that's the one test of irreducible minimum, impair the very essence and nothing else, if that was hinted at by Lord Hoffman, that's disapproved of by Lord Phillips as being of any general application. At paragraph 91. Baroness Hale's judgment in the majority paragraph 100 refers to Lord Bingham's paragraph 24, and then applying Article 2, Article 1, at paragraph 108 and 109 on page 215, domestic law illegality having to be accepted not enough on its own, the factual issues concerned fault and reasonableness or justification. Bottom of 108. Should it have taken the authorities so long to assess his needs, find the right place? Should they have left him without alternatives while this was taking place? These are factual issues which have not been fully investigated. If a new place could have been found sooner, or if there is more that could reasonably have been done, I find it hard to see how the effective denial of any education could be justified. What legitimate aim could it serve? How could it be proportionate to such an aim? So those questions of proportionality, of justification, are being posed there by Her Ladyship.
But on some aspects of that, she was in a minority of one.
My Lord, the question to confront, I suspect, is whether or not there is any dicta that prevents or binds this court against accepting the jurisprudence of the Strasbourg court to which I've referred and rely upon, that says that yes, you have to apply proportionality exercise in a circumstance where there's a restriction of this kind being imposed on a prisoner pursuing their education, and restricting their access to that institutional provision online. Now, that, my respectful submission is, whilst the domestic authorities have not been entirely clear as yet, there's nothing adverse, and in fact there's a little bit more help we can see in the Tigeri decision as well, in my respectful submission, in a moment, on this question of whether justification is separate. It applies essentially in Article 10 or other areas, or Article 14 justification, but wouldn't apply to an Article 2 Protocol 1 consideration on its own. And that doesn't, in my respectful submission, survive the dicta. And again, Lady Hale is one of those, Grouse Hale is one of those in that judgment. But there are several elements to the judgments of the court that I'll refer to. But before I leave this case, can I just deal with Mr. Lord Care, rather, paragraph 162, page 228. At 161, his lordship suggests next to, just below B, that the denial of education under the article can arise in a variety of ways. And at 162, there's reference to what was reasonably required. And a subsidiary, but nonetheless important issue, is whether any less ideal option should have been considered in the meantime in order to mitigate the harm. That's consistent with the proportionality exercise, of course, that one's looking at questions of justification for the action taken. In that case, it's the more difficult question of resourcing. You haven't got the resources to provide. It's not a deliberate restriction on access to anything. It's more that you're not yet putting in place the provision that other students receive in terms of their education. But even in the more difficult factual scenario, there remained the question of whether or not the authority had acted in a way that had done everything that they should have done to provide it. It's not asking the question in a general way as the minority may have done, but it's asking the detailed question as to what on the facts were the justifications for this omission, even if it's not a deliberate denial in the restriction cases. An example domestically of the application of both of these cases of Gray and Essex was attempted in the ZB and DB against Croydon decision, which is administrative court level, tab 20. I just mentioned that is a case in which the breach was found as the efforts were completely ineffectual to get the children to school. And that was a case where damages were required, £600 per calendar month, in fact, for missed education. But it doesn't, I think, help much on the principles. The next case, which my special does help, is the Tigeri decision at tab 13, in which there was unlawful discrimination against those in the country without indefinitely to remain, but having spent most of their lives here in the UK, in terms of their right to access education. Page 398, and in this instance, Baroness Hale and Lord Care give the same judgment. Lord Care agrees with Baroness Hale and doesn't provide his own judgment. Paragraph 23, page 398, reference to the Sahin and Turkey decision, and Her Ladyship accepting, as the court says, so fundamental is the role that education plays in the furtherance of human rights in a democratic society that the article should not be given a restrictive interpretation. Paragraph 24, that it should have the practical and effective, not theoretical or illusory, right in its interpretation application. And she then considers, in this case, which is really about the effects of immigration status on student loans availability, and the lack of the loan being made available to other university students, not to her, was said to constitute an unjustified denial of her right to education. Now, that's interesting, of course, because funding by way of a loan is a means to support your access to your education, but it's not saying you can't enrol and go to the university. So it's in the more difficult resourcing area in which one finds some of these cases go, but that doesn't alter the fact that what one is concerned about at paragraph 26 is the issue is justification. So again, it doesn't matter in harmony in the convention terms to say it's Article 2, Protocol 1 which is concerned. It is no different in the consideration that needs to be given to if one's invoking Article 14 on the inequality of treatment, and one might say prisoners having status in that regard. But sorry.
No,
So she goes a little bit
looking
further.
at paragraph 1 of the head note, it's sort of obvious that the state is not obliged by A2, P1 to provide or fund tertiary education. But it couldn't, for example, say we'll provide it for men but not for women. Or,
Yes.
And the other aspects of what led the majority to find in the claimant's favour are because it's reasonable to restrict benefits to those genuinely integrated in society. It's reasonable to target those who were part of the community and so on, but it's not reasonable to distinguish between those who are here legitimately pursuant to long-term leave to remain and those who were born here, as it were.
My lord, I don't know. I think certainly what one can see why the majority reaches their decision.
Yeah.
The usefulness of this case, it is in the funding category, which is the rather more difficult or unrelated area to the current, given that I'm not pursuing the funding issue. It is that what was said about the interrelationship, because of course one can posit that as a discrimination, an inequality, or one can posit it as an access to right to education. It was posited as both. And the court in relation to Article 2, Protocol 1 is clear that the question is the issue of justification. And that's, in my respect submission, consistent with the appellant's case, that there is, whether you call it Article 2, Protocol 1, or you call it Article 14, or you call it Article 10, no distinction in principle or in practice in whether or not the question of justification arises where you interfere with that access, with the exercise of that right. You don't have to not have that right in exercise at all. You often will have an aspect of your private life, your freedom of communication, your right to access a lawyer or other matters, which is being interfered with. It may not be entirely prevented, but it can still be an unjustified restriction if it makes access and exercise of that right more difficult. And this is not a case before your lordships where we require to invest funding resources, or we require to overturn a legislative or executive decision in the margin of appreciation area of financing, for example, of resourcing, public resourcing, where of course one has the greater margin of appreciation and other concerns that come up where you're talking about resource allocation. So those complications there did not prevent the majority from finding that there'd been a breach, notwithstanding that the question of resources has been looked at. In paragraph 33 on page 401, we see an example of the fourfold proportionality test being set out there within the bundle. there's also some dicta from Her Ladyship about the importance of keeping up momentum to studies, etc., at paragraphs 40 and 41. They're more prayed in aid as assistance to the right's importance rather than helping on the principal point. Lord Hughes also found a blanket ban was too restrictive and not justified. His Lordship again referring to justification in paragraph 67 and 68 on page 410 and 411, finding the discrimination involved not justified in the exercise of the rights. You have a divisional court decision in the bundle also of Kebede, which preceded Tegeri and is referenced in it. I don't think it will assist you on the points to go to that, but there was, in that case, also Article 14 for a resourcing issue where there was differential treatment. That was in a case that I don't think deals with many of the points that we are concerned with. Hurley and Moore is more interesting, and if I can just show your Lordships that before I think we reach the break.
Yes,
that case is tab 9.
Time flies when we're listening to eloquent submissions. How far have you got to go, Mr. Ross?
Well, we have broken the back of it. My oral submissions are very significantly dealing with the Article 2, Protocol 1 point. There's a couple of brief citation of authority on the other two grounds. Factually, we've covered most matters that I thought the court would be assisted with to contextualise the argument. So we're well on course for me, I hope, to be done within around half an hour, which, when I spoke to my friend earlier, would be sufficient for her submissions, although we're obviously not allowing the court much time for consideration today, but we rather thought perhaps the court won't reach the need for deliberation today.
No, we'll reserve judgment, that's generous of Miss Teelan, but don't sort of run on to 2:30 and then you find you haven't
done what I need.
If you can sit down sooner than that, so much the better. Shall we just say which case you were going to go to next, and then perhaps we'll break off at this point.
Certainly. The next case will be tab 9.
Hurley and Moore.